It's not. Oh, there we go. I think I fixed it. I was sorry, guys. It's your legal bestie attorney, Symone, and this is another episode of Girl, Is That Legal? My apologies. I guess I had YouTube open on multiple windows. Can y'all hear me? Okay. Nope. There we go. Sorry, guys. Now we got it. Whoo, child, it's been a day. It's been a day. We got it. I don't know why I'm orange. I guess I do. Or I'm green. I'm green because my green screen ain't working. So, hey guys, hit that like, come on, and yes, I am in the jail cell, y'all. Because this very well, it could be Diddy's last week in his cell, honey. This could be it. It could be timed up for him. Or hit that like as you come on in. Or it could be that he's just gonna get transferred to another cell somewhere else. What do you guys think? I want to know in the chat. Yep. Let me know where you're watching from. And also, yes, I do have the jail cell. Dallas, Texas. Okay. What do you think the verdict is going to be? Remember, it's 3 different charges. So what we're going to talk about today, we are going to discuss these jury instructions. Well, correction, it is the jury verdict form, to be specific. Yes, if you're new here, hit that sorry, I'm looking a little ashy by the lips. But yes, so I just want to be clear. So these are the verdict forms. It's not the jury questionnaire yet. Right now, it's just a verdict form that we're going to go over. I'm going to share it with you guys. I want to get your thoughts. Cases are won and lost based on the jury form. And we've been talking about this case. We've been talking about the Diddy case, for the last 5-6 weeks now. And one of the things that we were talking about is that it's just, these offenses are not at all what I was expecting. I don't think it's what most people were expecting. We were expecting some of the stuff that Tony Busby talked about in his press conferences. We were expecting more of the things that Lil Rod talked about in his civil petition. The whole, drugging people and drugging girls and putting stuff in their alcohol, perhaps in the Ciroc bottle, or maybe it was, substances in the baby oil. So now that we're here, guys, I don't know. I think for the average jury, they're definitely going to need some really clear instructions. Because let me tell you this. I was in that courtroom daily. And when I sat in that courtroom, listening to testimony, I tell you what, it took me around about 2-3 days to figure out what the hell was the charge for Jane. I didn't know what the charge was, at least for the first day to day and a half. I was like, okay, what's he charged with regarding this witness? That's not a good sign. So let's just go ahead. I'm going to start putting them up. So what I'm going to put up first on the screen, this is the verdict sheet that the defense has proposed. Go and keep it nice and simple. Oh, sorry. Yeah, this trial was definitely anticlimactic. Question is, has RICO been proven? We finna see. Yeah, the prosecution is definitely going to need a great closing. They're going to need to bring it on home. And the challenge is, I don't feel like any of the witnesses that they presented, I got here a week late, so I did not see Cassie, but I didn't feel like any of the witnesses, except for day one with Mia, really moved me to feel any way emotionally for them. Okay. All right, so the verdict form, this is what is proposed by the defense. So the defense proposes one, the government proposes one, and then the judge hears the objections and he comes up with his own version. I wish I could do side by side. Hold on, let me see if there's a way to do side by side. I don't think so because they're all media. Let me see. I'm not trying. No, it's not. Okay. There you go. We'll leave it this way. I wish I could do side by side, but basically both sides propose, then the judge decides. Now, I want to let you know, verdict form is different than the jury instructions. Jury instructions are very dry and boring. I'll show you an example from the R. Kelly case real quick. The jury instructions are what helps them get to saying yes or no on the verdict form. Hit that like as you come on in here, right? I promise this is going to be dry and boring. I'm also going to keep it simple. All right, so it's already 7:08. Better chop. All right, so the verdict form is super simple. So it's 2 pages. Look at this. It's 2 pages for the defense. This is what they want us. They just want to ask. Count 1. So remember, there's only 4 counts, 5 counts. There's basically, the first count is racketeering. Then it's trafficking Cassie. It's the Mann Act of Cassie. That's taking her state to state as a hooker. Then there's trafficking Jane and taking Jane state to state as a hooker. Those are the 5 counts. Mind you, they didn't have Jane until April. So before that, it was just these first 3. But here we go. They just want us to ask, defense wants to know, how do you find the defendant guilty or not guilty? If you answer not guilty as to count 1, it says just proceed to count 2. And count 2 would be, now you have to evaluate whether he trafficked Cassie. But then it says, if you answer guilty, you got to put below there, which racketeering acts do you unanimously believe the defendant agreed would be committed? Notice the word is agreed. This is not saying, racketeering is not even saying that he did it. It's just that he agreed for it to occur. So that's how come the arson could be presented, right? They're not saying, did he arson the man, set the man's car on fire. They're just saying he agreed that if it happened, hey, we don't care. That he agreed would be committed. So, but notice, this leaves it to them to figure out which of the ones they're going to agree. So this is wise for the defense, because that's going to create all kind of confusion. And more than likely, if that's the only question, it's going to be so disorganized up in there that people are not going to unanimously agree, or it'll be very hectic and confusing to get people to process unanimously agree on each one. Yeah, Therese said those are too simple, right? But see, that's what the defense wants. They did a good job. The defense wants it to just be super simple, so you can just be like, no, you don't have to think about it. How many goats are getting sacrificed to get Diddy out? All right. And so then that's count 1. Let me just show you real quick. Count 2 is the trafficking. How do you find the defendant, guilty or not guilty? That's it. All right, Mann Act transportation. Did you take her as a hooker across state lines? Yes or no? Guilty or not guilty? Guilty or not guilty? Now, we're going to compare it. We better compare it to the government's form. Now, this government form, that one was 2 pages. This 4. First of all, and I want to see your questions. I lost you with the last one. Which one? The Mann Act. So the Mann Act, that was the transportation for prostitution. That was that charge. Yes, I clearly see RICO. So remember, the simpler the form is, probably the more likely he's going to get a not guilty, right? Because nobody wants to have to sit there and think, like, remember, each of these crimes, they're not traditionally what the average person would think S trafficking looks like, or what they would think kidnapping looked like, or arson, or whatever. So you really have to think about the definition, unless you just want to be like, nope, not guilty. I don't want to think about it. Here we go. All right, so this is the government form. So here we go. Same thing, government, racketeering. How do you find the defendant with respect to count 1, racketeering, conspiracy? Guilty or not guilty. So that's A. But wait a minute. Here's what's different on this one. This one, below that, instead of the defense just had that one little simple piece of paper, below that, that was like, well, which ones do y'all agree on? And it's going to be none of them. Like, which ones do y'all agree on? Here you go. This one breaks it down. So this was the defense. It says here, like, you got to put on the blank. Here we go. No, first one. Is he guilty or not guilty of racketeering? And then you're supposed to put on the break. So the thing is, without this, all the jurors have to go through one by one and figure out, if any, do they all unanimously agree? Whereas the government's one makes it super organized. So here's the government one. All right, it's A, B, C, whatever. So it says, if you have found the defendant guilty of racketeering, please indicate whether the pattern of racketeering activity the defendants agreed would be committed involved kidnapping, or included attempted napping, aiding and abetting napping, or conspiracy to commit napping in violation of California law. Oh, that was for the Kid Cudi one with Capricorn Clark. But check it below. It doesn't say guilty or not guilty. It just says proven or not proven. So the jurors have to go through each one and be like, okay, all 12, do we agree? The next one, same thing for kidnapping, but this is for New York law. This is when they took her into that the business warehouse or whatever for 5 days in a row and made her take lie detectors. Then C, this is for the charge of arson. Now, peep this. The language is that the defendant simply agreed would be committed. And, that indicate whether the pattern of racketeering activity that the defendant agreed would be committed involved either arson, attempted arson, including aiding and abetting arson. Who knows what that means? They got to define it. Or conspiracy to commit arson in violation of California. So basically, it could just be conspiracy, attempt. He doesn't have to do it himself. D says, if you found the defendant guilty of racketeering in count 1, indicate whether the pattern of activity the defendant agreed would be committed involved bribery, including attempted bribery, like if they didn't take the money, bribery, attempted bribery, aiding and abetting bribery, or conspiracy to commit bribery in violation of Cali, proven or not proven. E, whether the defendant agreed would be committed involved any tampering with a witness or victim, proven or not proven. So D and E are the two where I'm like, I think he's gonna be in trouble. D and E, keep that in mind. Then F, if you found blah 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 blah, F is forced labor. I still don't remember what forced labor is, and I'm a lawyer. Sorry guys, I don't remember. And I don't think that who was the forced labor? Whoever it was. I don't know. Maybe it was Cassie. I'm confused. The jury instructions are what has to define each law and apply it to the facts here. And that's what they read over and argue over to decide how to check the boxes on this form. And then G is X trafficking. Now check this out. This is how they did it. So we're on 2. Now we're on page 3. So it's simple, but not. So then now it says, again, they're still having the jury have to go through each of the RICO underlying crimes to decide which ones they agree was proven or not proven. And H is committed, whether he committed any crimes he committed involved transportation for purposes of prostitution, proven or unproven. I is, this is a new one. I involved inducement to travel for the purposes of hookers. Inducement to travel for the purposes of hookers. Y'all know what that one is for? I'm about to show you. Y'all know why they added that? That's for the men that couldn't get it up. That's for Mr. Freezer meat. Okay? Because some people were like, oh, well, they were like, well, sometimes they weren't doing it. It don't matter. If your freezer meat wasn't working, did I break down the NDA? Not today. Not today, I didn't. But no, if the freezer meat isn't working, it doesn't matter. If they tried to get you to be their hooker, that was sufficient. I believe Trump. Yeah, Trump will. Someone is asking, she wanted her job back because she had no other opportunities. Totally agree. Did I break down the NDA? No, I didn't. I have on my channel, but it's been a while. Diddy's NDA. It said she wanted, but the NDA is relevant to the bribery just real quickly. And that's because it's proof that, let me see if I still got a copy of it. Hold on. I'm gonna see actually if I do, because I sure used to. So basically what happened is when they, KK and when Diddy's staff bribed the staff to try to get rid of the footage of the beatdown, KK then took one of the security guards' IDs, took a picture of it, drafted an NDA, sent him the NDA, and then gave him the money. Let's see. Gave him the $100,000. See, Doe versus Sharp. Hold on a second. I'm going to see. I know I had. Let's see. Oh. All right. Diddy. Let me see if I have it. Oh, I don't need this thing. Non-disclosure. I can't spell. All right, I'm trying to see if I have the Diddy one. Wait. I think it's here. Wait. I'm looking for. Is this one it? Let me not go mess nothing up. Nope. Oh wait. No, that's the other one. All right, I will find that eventually because I definitely have looked at it a few times. What was it? It was Bad Boy, right? Yeah. Or something like that. Combs Enterprises or some crap like that. All right. Ooh. That didn't work. All right, let's get back to business. All right. I get so distracted. Sorry, guys. All right. So anyway, with the going back to the verdict sheet. So real quick, hit that like. We're going to hop into it because then I want to show you what they're arguing about. And this is going to make a world of difference. So again, they're going through on this. They have to go through each of the crimes. I is where the jury has to agree whether or not, quote, not just the prostitution, but that whether there was, that the defendant agreed would be committed any acts that involved inducement to travel for hookers, or, and that's in case that somebody couldn't get it up. And then J was distributing and possessing with the intent to distribute controlled substances. Remember, you don't have to sell them. It's just sharing them. I don't know my TV is so blurry, but it's just sharing them. It's not necessarily selling them. But what they're going to have to define, to see the definition, is going to be, how do you define this for RICO purposes? Like, is it 2 people? I share with 3 people, 2 people. What is it? It needs to be more clear. And then K, if you checked that it was proven for G, which is S trafficking, it then asks you whether as part of the racketeering conspiracy, did he agreed or did commit trafficking of Cassandra between in or about 2009 and in or about 2018. And then secondly, whether the same thing happened with Jane between May 21st and 2024. That time frame just sounds ridiculous based on the facts, but whatever. We've already gone over why I think those facts are crazy. And then count 2 is going to be trafficking Cassie. How do you find the defendant? Now they're going back to guilty or not guilty. Before it was proven or not proven. Transportation with the intent to commit hookers for Cassie. Guilty or not guilty. Count 4, trafficking. Remember, because there's a separate trafficking count that's standalone. Guilty or not guilty for Jane. And then transportation with intent to commit hookers regarding Jane. So in other words, they separately evaluate whether it happened to Jane and whether it happened to Cassie. But what was weird is on this one, y'all, you see it doesn't break down whether she was trafficked by force, fraud, or what was it? It was force, fraud, or coercion. They don't break that down. That's going to be in the jury instructions where if you decide it was either one of those 3, you're supposed to just say yes. And at the bottom it says, just sign that. Hold on. I was surprised they didn't break it down more. They said that's because y'all don't understand the predicates need to prove RICO. They only need 2. That is correct. Hold on. Let me see. Let me go ahead and play that real quick. I'm going to play the predicates real quick for RICO, and then I'm going to show you the big argument that can make a world of difference in the final jury instructions. Because, child, it's something that defense wants to slide on in there where I was like, wait a minute, guys. So hit that like button as y'all come on in. Hit that in as you're coming on in. Now, as you do, real quickly, I'm going to play the RICO clip again. This is a RICO clip I made at the beginning, like after week 1. I'm going to play it for you guys. I still feel as confident about the offenses that are listed in this video. So I'm going to play it, even though since then, obviously, more stuff has happened. Let me know if you can't hear it.
Many people are asking, where's the RICO? I'm your legal bestie attorney, Symone. I break down celebrity cases on social media. Here's what has to be shown. Number 1, that there's an enterprise. Number 2, that there's an agreement within the enterprise to operate for a common goal, and that there's a pattern of racketeering activity. First, we know there's an enterprise. It's literally called Sean Combs Enterprises. But the question is, are they agreeing to commit crimes? Secondly, the agreed upon goal. The prosecution is trying to show that these things were done at Diddy's instruction or with Diddy's consent in order to keep Diddy happy, that is a sufficient agreed upon goal for the enterprise. And third, and this is the part that most people are like, what the hey, we haven't seen anything here, is the pattern of racketeering activity. All they have to do is show 2 of these 8, from kidnapping, arson, bribery, tampering with a witness, forced labor, trafficking, transporting prostitutes across state lines, and possession with intent to distribute or distribution of narcotics or controlled substances. Here are some of the offenses the prosecution has already provided evidence of. Number 1, bribery. That was on day 1. The hotel worker stated that Diddy offered him money to make this go away. Now, he didn't take it, but that doesn't matter. Bribery is the ask. It has nothing to do with the taking. Furthermore, the hotel actually did accept $100,000 to make the tape go away, so that's sufficient proof of bribery. Number 2, tampering with a witness. When they paid off the hotel workers and told them not to speak, that was tampering with witnesses. Those were witnesses that could have confirmed the abuse. In addition, this was done for the purpose of protecting Diddy's brand. If that video had gotten out in 2016, he would have been dropped by all the different brands and all his sponsorships. So that's 2 right there. Bribery, tampering with witness. The transportation of prostitutes across state lines. Now, prostitution's super easy to prove. All they have to show is that it took place in 2 different states. 2 male hookers have already taken the stand and talked about the various cities where they were paid to have sex with Cassie. There's also been evidence presented of distribution of narcotics and controlled substances. Different assistants of Diddy talked about being instructed to obtain or even to pick up controlled substances for Diddy. In fact, one of them actually testified under immunity. So far there's been evidence of distribution of narcotics, tampering with witnesses, bribery, and prostitution across state lines. Now, what we still haven't seen proof of yet is the kidnapping charge. We are still yet to see info on, but we've seen a bit about forced labor. What we're likely going to see in the future is testimony that musicians were encouraged to take drugs in order to be able to stay up late and work all night. There's also been some proof of arson, although we're expecting to see something more concrete that might pin Diddy down for that arson. And of course, there is trafficking allegations. Now, RICO can be proven without proof of any sex trafficking. Let me know your questions down below. I'm your legal bestie, attorney Symone. Follow me on YouTube at Girl, Is That Legal? Many people are asking, where's the RICO? I'm your legal bestie, attorney Symone. I break down celebrity cases on social media. Here's what has to be shown. Number 1, that there's an enterprise.
Okay, so we got it. You got the gist. So of those, I want to see in the chat, do you think any of those have been proven for the basis of RICO? Any of those? Someone is asking, as you're putting your thing in the chat, they're asking about the Rule 29. Yes, so Rule 29 is a motion that defendants always make at the close of the prosecution's presentation of their case, where basically they're saying, oh, Your Honor, dismiss this action, find me not guilty, due to the fact that the prosecution has not met their burden on at least one thing. So that's been filed. It's not going to be granted. Blah, 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 blah. Let me just see if there's any updates on that motion, because some people are asking that letter motion. Da, 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 da. Yeah, oh, it's a renewed. There's a renewed motion for mistrial. And then, oh yeah, the different instructions. Just make sure. Oh, yes. Renewed motion for mistrial based on the misconduct, but then also just Rule 29 is just basically the fact that at the conclusion of evidence, it's not all there. So you always make that motion. It's a Hail Mary. It never gets granted, especially not in federal court, because it's the feds and they're a lot more careful than that. But this is what I do want to show you guys. All right. So generally jury instructions are what the jury reads over, considers to decide on their verdict form, right? So there's standard jury instructions. Literally, they're called pattern jury instructions. They come in these like civil procedure books, and you just kind of tweak it for the facts of your case. Well, I'm going to go over real quickly. This is what the defense has proposed as the jury instructions. And then the government said, hail to the no. So basically, they want specialized instructions. I'm not going to go over all these because they don't matter. But the ones I felt were most interesting is they want one on immunized witnesses. Basically, they want the jury to be informed that these people are probably liars if they've got immunity. There's something on specific investigative techniques that basically they want them to be able to infer that, for example, no fingerprints were taken or the fingerprints weren't compared at Kid Cudi's house to the arson stuff. They want jurors to be able to say, oh, well, no, I don't really trust it. Hang on. Yeah. And that's number 2, investigative techniques. And then they want to be able to, which the prosecution is like, no, the government is not the cops are not the government. So the government shouldn't be punished if a police division had, bad techniques. But what you can do is just use that and evaluate it to say, to what extent do you believe the evidence? Do you think it was sound, credible, or are you going to dismiss it? But you don't get to say that these cops are over here hiding evidence, etc., because they did not do a more thorough, what you would have felt was more thorough investigation. With the one that then there's also, they want instruction on evidence that was obtained from searches, on the defendant's testimony. This is normal because the defendant is not going to testify, as well as the defendant's rights to not testify. They want to make sure he's not going to be penalized for that. That's normal. Then they want one on voluntary intoxication. That was the interesting one. Bulk cash, nobody really cares about that. They'll just talk about, he walks around with big wads of money. They want to just basically make sure that the jury is not going to think he's a big fat drug dealer because he's got wads of cash. And then crimes defined by statute only. That's not a big deal. But the one that was of interest to me is the RICO statute of limitations. So I'm just going to hop to the immunized witnesses. So we're just going to talk about the witnesses. We're going to talk about voluntary intoxication claim, as well as the RICO statute of limitations, which really threw me for a loop. And this is what they want to be told. I'm laughing because it ain't happening. They want the jurors to be told this specifically about witnesses that testified under immunity. They wanted to say, you've heard testimony of a witness who testified under a grant of immunity. What this means is that the testimony of the witness may not be used against him in any criminal case except a prosecution for perjury, giving a false statement, or otherwise failing to comply with the immunity order. You're instructed that the government is entitled to call a witness, a person who has been granted immunity by order of this court, and that you may convict the defendant on the basis of a witness's testimony alone, even if they're immune. But if you find the testimony, only if you find the testimony proves the defendant guilty beyond a reasonable doubt. They're saying, however, this is where they're like, this bitch is lying. However, the testimony of a witness who has been granted immunity should be examined by you with greater care than the testimony of an ordinary witness. You should scrutinize it closely to determine whether or not it is colored in such a way as to place guilt upon the defendant in order to further the witness's own interest. For such a witness, confronted with the realization that he can win his own freedom by helping to convict another, has a motive to falsify his testimony. Such testimony should be scrutinized by you with great care, and you should act upon it with caution. Basically, don't believe them. They over there lying. Child. The prosecution, needless to say, was like, hell no, Your Honor. This is implying that we are encouraging lying and people are lying. So I don't think they're not going to get that wording. I get what they're getting at, though. But y'all, this is why they don't want a KK as their final and lead witness. This right here. Because of the statements like this, how they're saying, because first of all, whether they put that in there or not, that is how most people think. Like, okay, this person has immunity, so if they got a reason to lie. So what you don't want is this key witness who's supposed to be the mastermind solely talking under immunity. All they're going to do is be like, hey, don't believe KK. She's the mastermind. She's the one with immunity. Don't trust it. Absolutely not. So that was fight number one. And then I'm going to go to the intoxication. I want your thoughts on whether you think, there we go, Diddy's intoxication should be considered by the jury. Specific. No. Oh, here we go. It says, There's been evidence that the defendant may have been intoxicated at the time of the offenses with which he is charged. Intoxication or drunkenness in and of itself is not a legal defense to a criminal charge. However, intoxication or drunkenness may negate the existence of the defendant's intent to commit the crime that the government must prove. In other words, hey, he might be too drunk to request the hookers, or maybe he was too drunk to set cut his car on fire. Maybe he was too drunk to tamper with witnesses. I don't know. Or high, drunk or high. It says on the evidence before you, if you find the defendant was intoxicated, you may conclude that the defendant did not have the required intent. No. I'm just gonna jump over what the prosecutor said, because they got so aggravated. I was like, let's just read what the prosecutor said about this, because it's gonna stick that. Which was, I don't remember which one that is. Gotcha. They said, oh yeah, so it's this one, number 6. Basically, they said, while the defendant may have been occasionally intoxicated, there is no evidence in the record establishing this defendant was intoxicated for the entire period and thus could not form the requisite intent to be held liable. And it said the defendant's proposed instruction is misleading on this point. The first sentence of the paragraph can be read as to suggest that a juror may find that the defendant lacked the requisite intent for the crimes charged in the indictment if he was merely intoxicated at some point during the charged crimes. So like over the years. That's legally incorrect. And then it says, the law actually says that intoxication instruction was not warranted where evidence does not show that the defendant was drinking the entire time during the incident. Yeah, so basically, I don't think that's gonna fly. What they asked for instead, what the prosecution once it said, they're like, oh, okay, if you want to give a intoxication jury instruction, then this is what you need to do instead. This is what how it should sound. It says, it says, because the law is clear that regardless how intoxicated a defendant is, the question is whether a defendant is too intoxicated specifically to form the required intent. So they wanted to say, the government wants to say, if you find that the defendant was intoxicated throughout the entire course of his alleged participation in the crimes charged, all of them, you may conclude that the defendant did not have the required intent I described earlier. Yeah, that didn't happen. All right, so it was that one. For real, it says the prosecution dwelled on Diddy's use of Cialis. Yeah, that was, I was wondering, it took them too long to get to the Cialis. Because I was like, there's no way he's doing this naturally. Can't be. All right, let me show, but here's the one that I believe is problematic. So this, I read this one and I was holding my breath. All right, I'm just gonna hop to the last one. If you are a member of my membership at the higher 2 levels, all of these documents will be uploaded to, if you go to the post, I share a post for the members, and it will be one that has a link so that you can download these if you want them. But here we go. Pay close attention to this one, y'all, because this is the one, when I read it, I was like, oh, shoot. Here's what it says. The defendant, there you go. The defendant wants the jury to be informed. So remember, keep in mind, all those offenses under the RICO statute, y'all, and this is pertaining strictly to RICO. Let's be honest here. The truth of the matter is all of those offenses under the RICO charge, except for Jane and the mutual combat with Jane, statute of limitations passed on every single one of them. That's why they're being charged under RICO. The arson, the kidnapping, the hotel incident, it passed on those. The forced labor, for the most part, unless they Yeah, even the forced labor, unless they count Jane. Now, the distribution of substances, that one has not expired. But for all the other underlying RICO offenses, the statute of limitations expired. However, by trying it under RICO, it allows for the longer statute of limitations. So the defense wants this instruction, y'all. It says RICO has a 5-year statute of limitation, told y'all. Therefore, you must determine whether the RICO conspiracy charged in count 1, it says count on, they got to work on their typos, and count 1, and the defendant's participation in the charged conspiracy, whether it continued beyond September 12th of 2019, because that's 5 years from when he was indicted. It says, even if you find that the charge enterprise existed beyond that date, you still must be satisfied beyond a reasonable doubt that the defendant knowingly participated in the charge RICO conspiracy in count 1 after September 12th of 2019. The conspiracy ends when the purposes of the conspiracy have either been accomplished or abandoned, usually evidenced by the last overt act. I'm going to explain what this means in regular words. And a co-conspirator ceases to participate in the conspiracy if he or she withdraws and disassociates from it. In other words, when I first read this, I was like, oh, shoot, that's a problem. Because some of the biggest stuff, right? Like the bribery, the tampering with the witness, the clear cut stuff was way before 2019. Like even the hotel incident, that was 2016. So if they get this in, they could probably win RICO. As in he could be found not guilty of RICO. Because now it still would leave the substance distribution. But that substance distribution that Brandon was talking about, it wasn't like partying with groups of people, Brandon Paul, partying with groups of people and stuff like that. So I don't know if that substance distribution, 12 jurors are going to find it to substantiate RICO. That stuff went after 2019. And the stuff pertaining to Jane occurred after 19. But nobody paid no attention to Jane's claim. Sorry, Jane. No. Now the hookers extended past 19. That we have evidence of. Because Jane had them hookers for her birthday in 2023, 2024. Jane was hooking. So we do have those two. But what I'm saying is here, the way that they're saying it is that you have to show, in other words, because of that statute of limitations being September 19th of 19, defense is saying you have to show that Diddy continued to participate in the conspiracy after 2019. And you have to believe that beyond a reasonable doubt, that he knowingly participated in activities. And remember, it still just has to be the 2. But you notice nowhere on here is it telling people 2 of 10 or 2 of the 8. It's just asking, which did you find? That's suspect. Yep. It's just saying that the conspiracy itself, you have to show that it continued, as in he was still colluding with his staff and they were doing stuff after 19. Yeah, let's see. We got a super chat. Based on the predicate acts list, is it basically case closed based on the bribery of the hotel and the extortion of Cassie's mom as the minimum? HFG, thank you so much for that super chat. So, see, Cassie's mom's a tough one because that's not in the indictment. Cassie's mom was blackmailed. There's no blackmail in the indictment. The indictment has tampering with witnesses and stuff, but hers is just being a terrible person. Here we go. I got the indictment right here. Yeah, there's nothing for the. So, I mean, it shows. Like I said, it shows he's a horrible person, but I'm putting it up right here. Look, here they are. There's nothing for. I don't know where they would put that. I mean, unless it's obstruction, as it means. Here's the offenses. Here they are. All right, here we are. Multiple acts. Kidnapping. I'm going to take this. I'm going to take this out of the screen. There's no extortion. People keep talking about it. Even news anchors were talking about it. I was like, dang, no extortion. It just says A is kidnapping, B is arson. C was multiple acts of bribery under the following laws: bribery witness, abetting, abetting. All that was California. What happened to Cassie's mom was Connecticut. Then it's relating to tampering with a witness, blah, blah, blah. No, her mom wasn't tampering with a witness, not forced labor. What happened with the mom was part of the trafficking. That was part of the coercion. That's what they're trying to say. It was part of the coercion that made Cassie feel compelled to stay. Because the other items on here, G would be transportation and inducement to travel for purposes of hookers and possession of substances. So yeah, the mom's situation is just an element of the coercion. Thank you so much, Natalie. Thank you for being here. And I want to show you one other thing, y'all. Somebody said, he is guilty if you let go people. Well, yes, if you let him, I agree. People, if you let that man go, people will be in a lot of danger. Now I want to show you this real quick. We got to go back to that statute of limitations document. Because I was like, wait. If he can only be found liable for stuff after 2019, but that's not true. They want to include language. That you see how that language is confusing to the jury. Put it back up here. That language was confusing. They want to sit up here and make people think like, oh, okay, we can only focus on things that happen after 2019. Well, that wouldn't make sense, because why would they have showed all this other testimony? And the RICO law actually says it could be two underlying offenses that happen within 10 years of each other. So this was the language that the defense is proposing. If they get it in, the prosecution could be screwed, because I could see how multiple jurors could read that, this whole part about it needs to have occurred after 2019, and then not consider stuff like the bribery, the tampering with the witnesses, the clear cut stuff. Now, this is what the government said. Oh, baby, the government tried to check him. Yes, the government tried to check him. Hit that like, y'all. Hit that subscribe, please. We're almost wrapping up here. This is what the government said to me. Because I was thinking to myself, I had been wondering, like, how does this statute of limitations situation work? But the government actually answered it and was pretty clear. She says, this is in number 9. All right. It says, the government objects to the defendant's proposed instruction about the RICO statute of limitation as misleading. That's number 9 at the bottom. It says, as written, this proposed instruction suggests that the government must prove the defendant, quote, continued his participation or knowingly participated in the charged conspiracy beyond September 12th, 2019. She said this is legally incorrect. In fact, once the government meets the burden of showing that a conspiracy existed, remember that's the 2 predicate acts, then the government is entitled to a presumption that the conspiracy continued until the defendant demonstrated otherwise. It said, the burden is on the defendant to prove that he took affirmative steps to withdraw from the conspiracy or that the conspiracy was terminated. A defendant must produce, quote, affirmative evidence of withdrawal, demonstrating that he performed some kind of act like withdrawal, like, I don't want to do this anymore, guys, or something like that, to leave the conspiracy, that he made a clean break and he has to communicate that to the authorities, or communication of the abandonment of the conspiracy in a manner that is reasonably calculated to reach the co-conspirators. In other words, once a jury finds, hey, 2 of these things have been met, the burden is on Diddy to say, oh, I wasn't in the group no more. I got jumped out the game. I left the game. I left the conspiracy. Quote, it says, accordingly, if the defendant intends to pursue a statute of limitation defense to the court on the basis that he withdrew from the conspiracy or that the conspiracy terminated before 2019, the government requests this reading. And obviously, he's the head of Combs Enterprises, so he ain't withdrew from nothing. They didn't become Christian until after the video of him Dragon, that girl came out and he was over there in Bali. All of a sudden he was, so I love Jesus. Oh, I'm just a bad, oh, I got to get my life together. But the language that the government is now proposing is this. They're like, so first the government wasn't even speaking to that statute of limitations, right? They're like, if you want to put that bull, this is what we want. Instead, it says, and this is our final point. It says, a conspiracy once formed is presumed to continue until either its objective is accomplished or there is some affirmative act of termination by its members. Once a person is found to be a member of a conspiracy, that person is presumed to continue being a member in the venture until the venture is terminated, unless it's shown by some affirmative proof that Diddy withdrew and disassociated himself. Now, in order to withdraw, though, from the conspiracy, Diddy must have taken some clear, definite affirmative act to terminate his participation, to abandon the legal objective. If the evidence only shows that Diddy stopped activities in furtherance of the conspiracy, so he stopped whooping on women, because he only whooped on Jane when there was that mutual combat that one day. It says that the evidence shows that the defendant stopped activities in furtherance of the conspiracy, or stopped cooperating with the conspiracy, or merely was inactive for a period of time, that ain't enough. Quote, the defendant has the burden of proving by a preponderance of the evidence he withdrew from the conspiracy. And preponderance of the evidence is not beyond a reasonable doubt. It just says 51%. Like if two things are on a scale, the scale can't even be even. If two things are on a scale, like if the jury's weighing the evidence and they're like, oh, I don't know if he withdrew with it, I think he was still part of this conspiracy. If they feel like it's even between leaning towards the defense and the government, you got to go towards the government if it's preponderance of the evidence. Otherwise, basically, you need 51% if you're going to see it that way. And then it says, if the scale tips in favor of the government, or if the credible evidence appears to be equally balanced, or if you cannot say on which side the credible evidence is heavier with respect to him withdrawing from the conspiracy, then you must decide the defendant has not proven his defense of withdrawal, i.e. the statute of limitations. Long story short, the defense was trying to get in there this timing, this language of the 5 years statute of limitations, because that is what it is for domestic violence. That's what it is. And they're trying to get domestic DV in everybody's mind, right? Think TV. This is all state offenses. The feds are just overcharging. So that's brilliant of them to attempt that, because they want you to think, oh, all of this is supposed to be state charges. All of this is trumped up, state. So if the defense gets that in, that's going to be a huge win for them. I think the jurors will think of it that way. And then the jurors are probably going to only focus on those items that happen, or those crimes that happen after 19. And the ones that happen after 19 are not the clear-cut ones. The ones that are after 19 are pretty much Jane, who we already are like, hell no. The distribution of substances, some of the hookers, and the alleged trafficking of Jane and Jane only. It says he's going to go broke. Not just Diddy get them all. There's others. Yeah, there are a lot of civil suits. He's still going to have to deal with his civil suits. That's for sure. 4 women that testified, but 2 others that were mentioned that did not testify. What happened to the chef, y'all? Why didn't the chef? I thought the chef was supposed to help prove forced labor. Yes, Kenya. I don't think the prosecution would pursue this if they didn't believe they could prove it. I think so too, especially Damian Williams, the former U.S. attorney. But I also don't know if what we are seeing now is the vision of what they thought the case would be back when they brought it initially. Because I don't think no one expected Diddy to ask for a speedy trial. Generally, this case would take 2 years. So there would be more time to secure witnesses and make sure they don't disappear and confirm evidence and have stronger facts. But Diddy called their bluff, and they apparently weren't ready. You couldn't even get the chef. Now the chef was forced labor for sure. The chef it was some stuff that happened with that chef now. He definitely abused her. Thank you. Hit that like. What do I think about what do you think the prosecution, like, oh, you're asking somebody else. The prosecution are a 6-pack of, I thought they were a 6-pack of cat ladies. Forced labor was the assistant. It was one of the people. It was also actually supposed to be more, I think Dawn Rashad was supposed to be helping prove up forced labor, but there were just a lot of objections and they were unable to get in a lot of that evidence. A lot. Yeah, forced labor is supposed to be the cook. Forced labor is also, he allegedly was making them dance, practice, all that stuff, all times of night, and was distributing substances to them so that they could stay up all night and work. Don talked about like him passing it out and she wouldn't take it, she would pretend to. Will the jury have to base their decision on RICO criminal intent? It wouldn't be a RICO. No. RICO is specific intent, so no. General intent. So no, they don't have to have a specific state of mind for those. And they're all like attempts or conspiracy. Oh wait, it actually says that in here. Hold on. Let me just make sure I'm saying that right. Yeah, because they talked about this when they talked about the intoxication silliness. Hold on. It says, yeah, the intoxication was very intoxicated, regardless. Defendant questioned whether it is not intoxicated. I'm going. It's the problem. Here we go. The intoxication. Oh, there we go. Voluntary intoxication does not negate general intent. La 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 la. The defendant may have been occasionally, in the event there's insufficient foundation, each of the crimes in the indictment is alleged to have occurred over different periods, and the defendant wasn't, the record is established the defendant was intoxicated for those entire periods, or that he was not, and thus could not form the requisite intent, basically. So there are some of those underlying RICO conspiracies. Some of them do have a specific intent, some, but not all. And those particular ones, I guess, intoxication would matter, but only if they could show he was basically intoxicated or high. Remember, high counts throughout the majority of that time. Let me see if I missed any questions. Jurors are very unpredictable, and I don't think that these are the smartest people. They're not the smartest people in the study hall. That's for darn sure. Hey, Kathy, thank you again for the super chat. I hope they explain to this jury as well. Yeah. Oh, thank you so much, Kathy. So it's going to be super boring. I actually want to sit in there and I want to hear it. So that it gets all typed up. Probably tonight and tomorrow. I actually think, tonight and tomorrow they're going to type it all up. They're going to go back and forth, and the judge actually reads it to them. It's a lot of pages. He reads it to them, and then they each get a copy of the instructions, and then only the foreman gets the verdict form to, like, they can look at it, but he's the only one that's going to fill it out to make sure it's right. And HFS is based on the predicate act list. Is it basically case closed based on, we talked about that. Based on the bribery, I believe so. Yeah, I don't see any way of getting out of the bribery and tampering with witnesses, or because the witnesses that were bribed were tampered with, or getting out of the hookers across state lines. Yeah, the forced labor was the employees, but they're going to have to really sum that up together really well in closing, because they need to clean it all up. Brendan the Mule was less than 5 years ago. Yes. Taking workers to another country is less. Yes, correct, Amber. So I'm saying that's going to be, so that's what I said the distribution is less than 5 years. So are the hookers, distribution hookers. But the challenge is the distribution that happened more recently. Like Cassie discussed distribution that seemed to be on a less personal level. That was more RICO. But again, if you have your staff distributing substances to you, even if it's just your staff going to go get you crack and you taking it at home, that can still be RICO, because you're using literally your staff to commit crimes for the betterment of you, which was one of the common purposes of the RICO enterprise. So it can happen. I just think that it's a weaker one. What I was just saying regarding the 5 years is it seems that the strongest offenses, which were the bribery and tampering with witnesses, as well as the prosecution, primarily happen prior to the 5-year mark. That's all I'm saying. So RICO it can still happen. It's really going to be, are the jurors going to read it, understand it, and follow the law? Or is it going to be too complicated where at least one juror is like, I ain't doing it. I ain't doing it. Because keep in mind, they don't even know how much time he's going to be facing. They're not supposed to know. If they were to find out from social media or otherwise, they are supposed to be replaced and be an alternate juror. So stay tuned. I'm your legal bestie, attorney Symone. Hit that like and subscribe on your way out and drop your questions below. Thanks, guys.